Over to you.
Thank you so much, Chair. Chair, I think by means of starting to appreciate the Competition Commission for the role they play in terms of really dealing with the issues of economic inequality and the misconduct that is done by players, big players in the country. While on the face of it, the two reports, which is market concentration and the currency manipulation, may appear to be two separate instances or two separate reports which are not interlinked. But my assertion is that there is some form of a link because what then leads to issues pertaining to currency manipulation or collusion between players in any industry is the fact that the market is concentrated. Therefore, dealing with the issues of the market concentration does assist in terms of weakening the role of or weakening the possibility of cartels forming in concentrated markets. But if I can start with the first report, which is the issues of the market concentration, I've got a few questions. The first question there is that with the market concentration, what impact does it have on unemployment and low economic growth? My assertion is that once you have very dominant players, few players that are dominant in the economy, when they reach the ceiling in terms of this particular market, the South African market, they invest in other economies, and the outcome of that is the investments are drained from this economy to other economies. So that affects economic growth, it affects the unemployment levels. So I wanted to understand from the Commissioner, with the issues pertaining the market concentration, what impact does it then have on unemployment and the low economic growth? And how could the issues pertaining to market concentration in South Africa be also viewed as a legacy of the apartheid economy or the apartheid times? We know that during the times of apartheid, the economy was for a particular racial group. So can this market concentration of the South African economy then be also understood that it is still a legacy of the apartheid economy, or how the economy was run during the times of apartheid? And then the last question, or second last question on this issue, it is then the role of government on two fronts. With the government having 3 trillion annual spend, and them spending over 80% on that on big business, which are the dominant players that the commissioner spoke about, does that not then entrench the very same concentration that we're talking about? Also, with the issues of the legislation that should be driven by government to ensure that the barriers to entry are disabled. So the last question, if I can put it differently, is to try and understand from the commissioner their perspective on how has the government failed, one, on failing to introduce legislation that would disable the barriers to entry for the many businesses that want to enter in some industries. On the second part of the question, how the government spending in itself, when it spends over 80% of its budget on these very few dominant players, does it then not also go a long way in terms of entrenching the market concentration problem that we see now? Because we saw how it happened in Botswana, where they were heavily reliant on produce that was sourced from South African farmers. But when the government was very clear to say certain percentage must be sourced from local farmers, and that percentage kept rising and rising to an extent now that Botswana is self-sufficient when it comes to the produce. They no longer need to source from South Africa. However, in our country, it does not seem as if the government is doing enough in terms of deconcentration the market to enable new players, to enable different players to be able to participate. So that was my submissions on the first part. The second part on the issue of the rand manipulation, I can't stress this enough, Chair, to appreciate the role that has been played by the Commission. The fact that it has taken this long and the Commission has remained steadfast in fighting for justice to ensure that the white collar crimes are basically treated the same as the other crimes, and there's actual accountability against all of the wrongdoers. And it's not the first time, maybe could not be the last time either, where you are going to have cartels forming and manipulating processes, manipulating the economy for their own selfish interests. We saw with the construction of the World Cup stadiums, there was collusion there by the big construction firms. We saw with the bread price collusion. So it is not different with what is happening with the case of the rent manipulation. So the biggest issue is that in our country, it seems as if there's really accountability on the white collar crimes. I think they're treated differently. So to have the Competition Commission actually standing up and wanting justice on this matter is something that we really, really applaud. So I've got a few questions. The first question is in relation to now the economic impact when it comes to the issues of the rent manipulation. What was the economic impact on the economy and the cost of living and the general economic well-being of South Africans? Because I think this crisis, I know that we've previously said, it is akin to treason. It is akin to a crime, economic crimes against the people. So people don't really understand how much the issue of rent manipulation affects, a student, affects a young professional, affects a pensioner, affects each and every person in this country, given the widespread impact it has, whether a person is in Mosina or a person is in Cape Town or a person is a student, a person is a retiree. The impact of rent manipulation must be well understood in terms of the impact it has on ordinary South African citizens. Then the other question is in relation to the other countries that have had such instances of currency manipulation. How has those countries actually dealt with that when it comes to the fines and the executives being prosecuted personally now? Because the fact that we are going to have crimes that are committed, but you find that the executives of these banks are not having any form of prosecutions against them as individuals, whereas in other countries, not only do they charge the banks in their capacity as private companies, but they also charge the individuals that have been taking these decisions, because there are people who are holding positions in these banks who take these decisions to basically commit these crimes. So I just want to understand from the commissioner whether have they looked at how the conduct has been dealt with in other countries and what then would have been the outcome, or what could be learned from those countries. Also want to echo what the colleague said about the issues pertaining to the fines relative to the money that these banks made. Can't be that a bank will make 500 million over that period, but it is only fined 50 million. Are the fines adequate relative to the money that the banks or the profits the banks made during that period? And can the commission then maybe confidently say, currently as we speak, or after the case that we're dealing with now, or the period that we're dealing with now, has there been no other instances where they can confidently say there is no rent manipulation? Can they confidently say there is enough legislation, there's enough mechanisms to somewhat block or prohibit any form of currency manipulation after the case or the period that we're dealing with now. Then the last question to the commissioner, the committee, how can the committee be of help in terms of ensuring that the Competition Commission is able to fight these crimes, and there is no legislative loopholes that enable then the particular wrongdoers to get away with the crimes being committed? I thank you, Chair. That was my submission.
Chair, there's no further hands, Chair.
Is there no further hands?
No further hands, Chair.
Okay, let's allow Commissioner and your team to respond. We'll come back.
Thank you so much to you, Honorable Chair and Honorable members, for those questions and comments. I will start, Chair, on the questions. First on the cartel ones, and I will and then I will then do a bit of a brief overview on the concentration report. There are some broader questions that have been asked, and I'll deal with them. And then on the detailed question, I will ask the team led by Dr. Harry Passard to then answer some of those questions. Chair, let me first say, in relation to the questions on evidence, as you said, Chair, right from the beginning, it would be hard to answer those because the matter is still going through to the courts, and we don't want to compromise our litigation strategy as the Commission going forward. But just to say this part, what the court required, what the court said in relation to the evidence linking some of the respondents, it was about linking the conduct of the foreign firms with the local firm in South Africa for us to be able to sustain the single overarching conspiracy case that we brought about. So it was a technical issue linked to the jurisdiction question, Chair. And so and that's why the issue of Section 3.1 or the interpretation of Section 3.1 was so critical, Chair. But the court did not resolve that. And because it didn't resolve it, it meant it stayed with the interpretation of what Section 3.1 said, requiring us to do so. So, and that is what led to this issue. On the effects of the conduct on the economy, that is evidence that still needs to be presented before the tribunal, Chair, and it's another matter that I will not want to engage on because it's still something that still has to go before the tribunal. When you are engaging in this way, you are then required in court to talk about the effect of the conduct in the market. So that part is still to be dealt with. The countries, you are correct, both Member Tring and Member Zungula, that these cases were dealt with in other countries. The US dealt with it, the UK dealt with it, and Europe dealt with it. In Australia, I think it was it was a private litigation that happened on it, and so they did, and I think Member Chance also asked, and they were found guilty in these countries. On the fines, just to say, they were fined, all of these firms in those countries, but our fines are dictated to by Section 59, and what the Act essentially does is you look at the conduct and the revenue in relation to that conduct. So not all of the revenue of the respondent, but the one relating to that conduct, and so the calculation of the two fines both against Citibank and against Standard Chartered Bank were in line with the provisions of the Act, and and this answers a little bit of the question on legislative amendment. You'll recall that there were amendments to the Competition Act in 2019. One of those amendments was to introduce another increase in the percentage of turnover that you fine from 10% for the first conduct to 25% for the second conduct, so that if a party has another conduct that they are found guilty of, having been fined in line with the first offense, they may face a 25% turnover fine at the time. Just on prosecution, you'll recall that our act was amended to allow for prosecution of cartel conduct where the parties have been found guilty. So there is that. We are still engaging with the NPA on the process of doing so, Honorable Chair. In the US, I think there were prison sentences against the respondents who were found guilty. Remember, in the US, you have of criminal conduct, which will be litigated by the DOJ, and the more civil, which will be litigated by the Federal Trade Commission. And so those were fined, and in some instances, prison sentences imposed in relation to them. Chair, the difficulty, that is raised by some of the honorable members relating to what I earlier called interlocutory proceedings is quite real, and that's why, in fact, we would have raised with the committee in November 24 when we presented why the importance of going to the Constitutional Court to get jurisprudence clearly articulated by the ConCourt in some of these matters. And that's the way you use precedent as a mechanism for compliance, because what the courts have done, the Constitutional Court has done, is to at least create some clarity in respect of some of these interlocutory proceedings, which tend to take so long in conduct cases that we have seen. And this happens a lot of the time, Chair, where you have interlocutory application, either as an exception or dismissal application, and they just go on and on. So we did need a bit of clarity from the court, and we are grateful that the court granted, at least in respect of some of those cases or some of those issues, clarity, and that's what will enable us to make sure that the matter gets to the tribunal and it's not delayed. Obviously, we can't stop respondents from raising interlocutory applications. However, where the legal principles are sound and clearer, it assists us as the Commission, as a regulator, to ensure that those issues are dealt with. Chair, we will come back, obviously, on legislative review. But let me say this, both on the concentration and even on Cartel, the amendments in 2019 were quite extensive to try and help the Commission to deal with some of the concerns, including, Chair, participation and expansion by small and medium enterprises and firms owned or controlled by historically disadvantaged persons. The main aim, you recall, Chair, of the amendments that Parliament passed in 2019 were to deal with this, including the amendment or the insertion of Section 12A3C and 12A3E in major proceedings, both for ownership of by HDP and firms and workers, and participation by small and medium enterprises and HDP firms. So that was quite critical, and as the Commission, you would see in a current 5-year strategy, we are concentrating on ensuring that we implement the provisions of those amendments to allow us to do so. Chair, just I think Honorable Zungula in the end on the concentration report raised some issues, and which I want to say the following. Yes, Honorable Zungula, you are correct. And as I said in my introductory remark, the Competition Act in its preamble and recognizes this, that the democratic South Africa inherited an economy that is highly concentrated, where historically disadvantaged persons were excluded from the past. So that is a legacy of the apartheid era laws and practices, and that therefore competition law and inclusion are very critical to ensuring that you get an economy that includes everyone, that performs at its best, because you have the resources that the country has to enable us to grow and have a competitive environment. And it is correct also that concentrated markets have a tendency to have outcomes that are anti-competitive, either leading to high pricing or lack of innovation, and therefore it's critical that we deal with a high concentration level. And as I said, Chair, it is an all-of-government approach to do so. And some of the programs that we are talking about, including the review of the regulatory environment to deal with regulatory barriers, is one of the critical aspects of the work that we are doing, so that whatever intervention we put in place as the Commission or government more broadly, it's based on evidence from the outcomes of this review work that we'll be doing. Chair, I think I have dealt with all the questions on cartels, and these are the introductory remarks on the question on on the concentration reports. Sorry, Chair, the only issue I had not mentioned, and I think it was asked by Honorable Gama, relating to leniency applicant. Yes, we do give a provisional leniency to an applicant. And that is on condition that they give us all the information we require and they cooperate with us in prosecuting the other respondents. And if they don't do that, if they don't cooperate, there is a possibility that the leniency may be withdrawn in line with our leniency policy. And we only grant total immunity once the matter is concluded. So I just wanted to say that, Chair. With that, I will then hand over to James Hodge, and then together with the team, they will deal with the other specific questions that were raised, Chair. Thank you very much. James?
Thank you, Commissioner. Chair and honourable members, it is James Hodge, the Chief Economist at the Competition Commission, who I oversaw the study that Dr. Govinda undertook. Maybe just to work through some of the questions, there were comments from Member Shring and Member Chance on the fact of easier to enter than expand, and I think some of the comments were the focus for DTIC and government more broadly moving forward to in fact look at that expansion. This we would agree with. If 80% of firms are micro and 13% are small, that's 93% of all firms in the economy. Clearly, we have a scaling problem. And so the focus should not necessarily be on adding more micro firms to the economy, but how do we scale those micro to small, the small to medium, and medium to large businesses? That does require somewhat of a rethink of our strategies around SMEs development. In terms of the next question from Member Shring on proposals for the rail sector, we have been active in issuing guidance as part of the general calls for comments on regulations and policies in both the energy and the rail sector. This is an opportunity to increase competition in logistics. Obviously involves a degree of privatization, but a balanced one where a lot of the infrastructure still remains in the hands of government, but services are put on top. So we'll continue to look at that and make proposals. On how many were investigated and prosecuted, my team has just done a quick calculation in the period 2017 to 2025. On abuse of dominance, 120 cases were investigated, of which 16 were referred to the Competition Tribunal, and there are some more pending at the moment. And for restricted practices, predominantly cartels, there were 304 cases investigated, of which 112 were referred to the Competition Tribunal. On the legislative review, as the Commissioner says, as indicated, we have started a major regulatory review program, which looks at getting inputs from business to identify barriers to them either entering or expanding into markets due to regulations in place by government. And in essence, this looks at different sort of barriers. It can be that there is a legislated restriction, such as licensing, which limits the number of participants and may do so unduly. It also looks at often cumulative effect of different regulations that require entry into, for instance, a market, be it registration, tax registration, environmental requirements, and other requirements. And so it is a fairly broad ambit. We've received comments across almost all the sectors of the economy, and then also specific comments around municipal level regulation as opposed to national. The next steps in that process that we're undertaking at the moment is we're engaging with the relevant government departments and municipalities around the rationale for those regulations or legislation, and whether those are unduly burdensome and can be simplified. in response to a question by member Zungula, regulations are often in place because there is a genuine concern. So, for instance, we regulate mergers because there's a genuine concern that these can increase concentration in the economy. But a recent review by ourselves of our own regulatory burden indicated that we could raise the thresholds and reduce the number of notifiable mergers in order to reduce the regulatory burden on business and pass through many smaller transactions that didn't raise competition concerns. So there is often a rationale for these, but it's determining whether it's unduly restrictive and can be either modified or the implementation improved, and in some cases completely removed as well. In terms of, Member Chance, your question about the apparent contradiction of concentration manufacturing and lower in financial sector. The statistic you refer to is just the number of sectors, but I would just want to point out that in financial markets, it is 9 out of the 45 subsectors that were identified as concentrated, but these account for the vast majority of the financial sector. So they cover monetary intermediation or your payment system, where the top 3 firms have 97% of the market. It includes reinsurance, where the top 3 have 92%. It includes insurance as well, pension funding. And so it's also the size of those markets that maybe we haven't reported on that might lead to that misunderstanding that the financial sector is not concentrated. We have, though, seen disruption in the financial sector, something we note. This is one of the biggest areas for investment in technology in the fintech and insurtech sectors. So there are some green shoots of competition. And of course, we've noted the success of Capitec, growing sense of Time Bank that are also starting to impact on the sector. In manufacturing, we're dealing with 71 different subsectors, some of which are relatively small. And if they're servicing just the domestic economy, there may be a limited market, and that leads to high levels of concentration. But that's the importance of trying to improve the global competitiveness of these sectors in order to grow and expand. In terms of Member Gama, your comment on economic power and whether that is changing, and particularly what is the lessons on transformation. So as part of the SARS administrative tax database, we do not have measures of transformation in the data set at the moment. Each year there are improvements to the data set, and we hope that in the future we'll be able to measure that. However, I would point you to a recent report that was released by the BEE Commission, which the Competition Commission assisted with our analytical team on the state of transformation and the level of trends. And that one, which I think may have been presented to Parliament already, but identified that after the codes of good practice were put in place in 2015-16, there was a surge in compliance, but that then effectively stalled. And in fact, we're seeing growing non-compliance now in many sectors. And so I think it would be useful to just review that report and see what you can get out of it. But it does end with a list of recommendations that are being put into the DTIC's review of the transformation legislation that is underway at the moment. Then Member Mosikatsi had a number of questions. I think the Commissioner has certainly answered some of them in terms of the impact on job creation and growth. And this was also a question from Member Zungula. The statistics which Dr. Govender showed is quite revealing in terms of job creation, that MSMEs account for only 22% of turnover, but 44% or double the amount of jobs in the economy, which shows that they are twice as labor intensive as the large firms. And that's why they are seen as a solution to the job creation issue, and why our lack of MSME development in the country does undermine job creation. It also does undermine growth. We are busy with a follow-on study using the same data set and also interviews with investors. But But what we are finding is that more competitive markets tend to promote greater levels of investment. And this is obviously because it facilitates more firms coming in to challenge. And it's the investment across the whole sector, not just the investment of a handful of big firms that matters. And so investment is higher under more competitive markets. But it's also important for competitiveness, which is a driver of growth. We sit with an economy that lacks a lot of competitiveness globally and is battling to expand exports. But competition in the local market drives productivity enhancements, which makes us more competitive globally and improves growth and investment beyond just what the domestic market can deliver. In terms of that participation over time, I think Dr. Govinder's presentation highlighted that there was a drop in participation, primarily because of COVID, which, as we all know, heavily impacted small businesses. We'll see as new data is released by National Treasury for the subsequent years whether there's been a rebound in that. But the data we have available from them that's clean and available for researchers is only unfortunately up to 2021. And so our subsequent reports will hopefully highlight that. But it is worrying that has declined, and even in the period before COVID had not improved. It was stagnant. So it is something that needs a sharp focus. In terms of what we need to do across government, I mean, we've put out some of the recommendations. One is the regulatory review, as the Commissioner touched on, and there we will be looking to, and we are already engaging government departments and municipalities on why certain regulations are in place. Can it be simplified? Can it be removed? And what are the risks associated with those regulations that warrant keeping them? So in a sense, we've taken a lead across that. But at the point when we put out recommendations, then we'd appreciate the support of this committee as well as obviously our ministry in having those acted upon across the different government departments and municipality levels as well. The other issue, which was also raised by Member Zungula, is procurement. Procurement is an important tool for both transformation and lower concentration in the economy. And certainly the latest procurement regulations issued by Treasury look to improve that going forward. And we have made some comments on those. But ensuring that procurement allows for the development of new expertise, the growth and expansion of challenger firms is important, along with the regulatory review in terms of what government can do in order to start to address the MSME problem, but also that problem of scaling small firms that have already demonstrated their capabilities in the market as well. So thank you, Chair. I think I've covered most of the remaining questions.